must be having difficulties.
Okay, we're about to start. Wednesday,
Yes, thank you, Avita. Go on.
Wednesday, the 8th of September, 2021, Commercial Court 2 via Zoom at 10:21 a.m. before the Honorable Justice Sabir Williams, Civil Jurisdiction 2019, number 200, Lynn Thompson versus the Public Service Commission and others. Mr. Dill for the applicant, Mr. Horstman for the first respondent, Mr. Mari for the second and third respondents.
One minute.
Yes, good morning, everyone. We were having an issue with live streaming, but I understand that that is rectified and we are now live streaming. Is that correct, Ms. O'Connor?
Yes, that's correct.
And the Court Smart is also running.
Yes.
Okay, thank you. Yes.
Good morning, milady.
Yes, good morning, Mr. Dill.
As you know, milady, I appear on behalf of the applicant in this matter.
Yes,
Can we just deal with some housekeeping first to make sure your ladyship should have copies of our submissions and authorities,
yes,
copies of both my learned friends' submissions and authorities.
yes,
You should also have a correspondence binder
yes,
and a pleadings binder.
yes.
Excellent. In addition, and I have to apologize, milady, our firm has been operating at about 50% capacity thanks to COVID quarantining issues. So there were some materials that were sent to you, to the registrar this morning via email.
It appears that they've made
They've made their way to you?
their way to me. If it's, you're talking about the regulations and the
Should, yes.
equipment code and the,
You should have an
Code of
extract.
conduct.
She should also have an extract, which we're not hopefully going to deal with until later on, an extract from Lewis on Judicial Remedies in Public Law, 6th
I
edition.
do,
I'm
yes,
grateful. Thank you, milady. So I will come to those in turn. I understand also from my learned friend, Mr. Horstman, that he sent you some authorities to deal with the quote, if I may use air quotes, the damages aspect. He sent those by email this morning.
we may have to come to that at some point.
Yeah.
Later on when
Sandy,
Mr.
I could maybe assist. I think Sandy came up and actually inserted them in my binder at 7, 8, and 9, so they should be in the binder.
Okay, all right.
Yeah,
good. Thank
great.
you.
So I don't think we will need to deal with those until later in any event, milady. So,
Yes.
milady, can I ask your ladyship to have to hand at this stage? Well, actually, perhaps I could ask you to go to the authorities, our authorities binder first.
Yes,
This is being, I do this in the hope of clarifying for all of us what the function of the Public Service Commission is about, because, and I readily confess that we've fallen, and in fact, even my learned friend, Mr. Horstman, fell into the trap of referring to using the word decisions of the Public Service Commission. So if I can ask your ladyship firstly to turn to tab 15.
yes,
This is, I'm looking at section 82, sub 1 and 2 of the Bermuda Constitution Order, my lady. Do you have it?
yes, I do.
So if you look at 1,
Mhm.
Subject to the provisions of this Constitution, the power to make appointments to public offices and to remove or exercise disciplinary control over persons holding or acting in such offices is vested in the governor, acting in accordance with the recommendation of the Public Service Commission.
Yes.
And then, quite importantly, two, this will become important later on, but I'll take you to it now. Before the Public Service Commission recommends to the governor the appointment of a person to the office of a permanent secretary or head of a department, which this position was, the commission shall consult the premier. Now, if I can just, while I'm there, my lady, and I don't know why we did it, but if you can turn to tab 14,
Mhm.
we've somehow managed to put the different sections in different tabs, but I'm looking at section 83
Yes.
of the Constitution Order,
Mhm.
which talks about the delegation of the governor's powers.
Yes.
So the governor, this is sub 1, acting in accordance with the recommendations of the Public Service Commission, made by regulations, delegate to such extent and subject to such conditions as may be specified in the regulations, the powers vested in him by section 82 of this Constitution, and then very importantly, other than powers in relation to the offices referred to in subsections 2, and that's the one we're talking about. So there is the ability to delegate appointments, but not appointments of, in inter alia, people who are persons who are going to be the head of a department.
Mhm.
That's going to be important, my lady, because you will see, and it's accepted, that throughout this entire exercise, the commission actually didn't make any recommendations to the governor at all. In fact, what was being done, would appear, is recommendations were made either to the ministry or to the head of the civil service. But the point I wanted to clarify in any event was that what the Public Service Commission does, or is supposed to do, is to make recommendations to the governor, and it is the governor who makes a determination whether to appoint or not. Now, I think it's also accepted tacitly by my friends that I don't think there's any occasion where a recommendation has been made by the PSC that hasn't been acted on by the governor. But that's how it's supposed to work.
Yes.
Now, if I can just turn to the facts, my lady, what I plan to do, subject to your ladyship's direction, is to try to go through the facts as quickly as I can, but this is a fact-intensive case.
Yes.
I would commend our submissions to your ladyship in any event, not least of which actually they weren't drafted by me, they were drafted by my learned friend, Mr. Richards, whose talents are clearly wasted in the matrimonial law arena, but enough of that. But the recitation of the facts in our submissions is fairly comprehensive. So, my lady, perhaps we can deal with it this. I plan on going through the facts as quickly as I can,
Yes.
taking your ladyship then to the some relevant documents, and then fortunately, there's not a lot of it. I don't think we quarrel too much on the authorities on the issue, just how the facts of this case translate into those authorities.
Yes.
So, my lady, the applicant was unanimously recommended by the interview panel.
Sorry, am I opening up any document to follow
Well,
you?
if your ladyship would just follow along, I actually open my our submissions, and
Okay.
I'm sort of
That's fine.
that paragraph 3 was where I.
Yes, it's fine.
Yep. So I'm going to, but I will skip some parts but anyway, was unanimously recommended for the position of Director of Parks. And then if you can actually ask your ladyship to read to yourself, you don't need me to read it out, paragraph 4, and you will see if I can put it this way, the glowing terms, and we'll go to the actual document later, of the then acting permanent secretary, Mr. Farrow, recommending the applicant be appointed. She was chosen out of 22 applicants, and she was the only one who was recommended. Now, what happened, now dropping down to paragraph 5, in May, the PSC deferred its decision for reasons that do not appear clear, but perhaps can be guessed at, as they wanted to meet with Mr. Farrow on the 2nd of July of 2018. At that meeting, whatever you want to call it, they raised questions about her management style. So this was an issue that was brought up by the PSC. So one must presuppose that that was the reason why they deferred their decision to meet with Mr. Farrow. Because up until then, the applicant had acted as director for almost 10 months without any issues being raised, save for one, which Mr. Farrow deals with in his affidavit. We'll come to it. And despite that, Mr. Farrow stated he was confident that any issues on management style could be handled. Importantly, milady, the applicant was not told of any of these issues. And in fact, what's even more surprising was these issues were raised with Mr. Farrow, and as he makes clear in his affidavit, they didn't even share those details with him. So the PSC then decided, or determined, or recommended, that she should act as a director for another 6 months with bi-monthly assessments, and therefore defer the final decision for a 6-month period. Now, a number of problems arise as a result of that, my lady, and this is perhaps where I'd ask you to make some notes if you wish, because the first question I would ask your ladyship to determine was this decision, i.e., we're going to put her in the position as acting for another 6 months, logical or rational? In light of the fact, we would say a resounding no. Firstly, she had already acted for 10 months. Secondly, under the regulations, a permanent appointment carried with it a mandatory 6-month probation period, and there were options to extend that period, probationary period, if necessary. And then, so my lady, can I ask your ladyship to take up one of the ones that were brought in by hand today?
Yes.
That's the Public Service Commission regulations.
Yes.
And if you can turn to page 11, it's the only, that's section 21.
Probationary period.
Regulation 21. Yes, under heading probationary period. Subject to paragraph 2, which doesn't apply, every appointment to an established office or to a temporary post in the public service exceeding 1 year from the date of appointment shall be made in accordance with the recommendation of the Commission, subject to a probationary period of 6 months. So what they did was, in essence, they were saying, okay, so we'll have her in, we'll quote recommend, we'll come on to the issue of the recommendation in a minute. We're going to recommend that she act in the post for another 6 months. And then assuming she performs that satisfactorily, she will then receive a substantive appointment. But the substantive appointment itself had a period of 6 months already built into it. So why, we would ask the question, would you subject someone to a 1 year period of probation, i.e. 2 consecutive terms of 6 months? We would say that simply isn't a logical or rational decision. And then thirdly, my lady, a very important question, who was this recommendation or decision made to? We know, and it's conceded, that it wasn't made to the governor. If your ladyship can take up my learned friends for the third respondent's submissions, if your ladyship has those to hand, if you could turn to page 4 of my friend's submissions there, paragraph 2 under the heading of legal.
Sorry, I've just lost.
I'm sorry.
touch of them. The bigger desk. They were loosely from his blue folder.
I don't know. I just have a. I'm sorry, my lady. I just have mine as a separate set.
The-
Oh, they're loose. Yeah, they're in a blue.
Yeah, I thought
Clear.
I've obviously taken them out of that blue folder. I meant to keep them in it. 1 minute. Split them into a folder. 1 minute. Not quite sure how that happened, but you'll just have to wait until I get my hands on it. Sorry.
My lady, if it assists, I can just read you the extract. It's not
Could you
controversial.
please, and then.
Yes,
I think
it's not
whenever we have the
controversial.
next
I think you
pause,
can.
I'll look for it.
Yes, it just for your ladyship's note. It is
Yes.
page 4
Yes.
of my friend's submissions.
Mm-hmm.
It's paragraph 2 on that page under the heading of legal analysis. And I'll just read it to you very quickly, my lady. He says, on behalf of the second respondent, I submit that because the second respondent never received any recommendation from the first respondent and took no part in any deliberations or decision of the first respondent, the second respondent, it says, goes on, should not be a party to these proceedings. Obviously take issue with him on the latter part of that. But for the purposes of my submission here, it's accepted that no recommendations were made to the governor.
Yes.
So then begs the question, who were these recommendations? Because you'll see it in my friend Mr. Horseman's submissions. Who were these recommendations made to? And that's why I took you right at the outset, my lady, to section 82 of the Constitution, because the only person the PSC is supposed to make recommendations to is the governor. Now, we don't know, but I'm assuming the recommendations were made to either the permanent secretary, whoever that it may be, or acting permanent secretary of the ministry at the time, or to the head of the civil service. But the simple point is they had no authority or remit to do so. So it's not the business of the ministry. It's the business of the governor. That's just one of many mistakes that have been made in this, sad to say, in this case. So moving on the chronology, my lady.
So one minute, before you go so far, I'm just looking at section 82, I've gone back to section 82.
Yes,
of
of
the
course, Maureen.
Constitution.
Yep.
The power that is vested in the governor is the power to make appointments to public
Yes.
offices.
Yes, my lady.
Then there's a further power to remove or exercise disciplinary control
Which we're not
over
concerned with.
persons who are holding or acting in such offices.
Yes.
And that's where you would place your emphasis.
Well, we're simply saying, just pull it. We're simply saying under 82(1),
Mhm.
it clearly sets out that the power to make appointments is vested in the governor
With the recommendation of the public
with
service.
the
yes.
recommendation of the Public Service Commission. It
Mhm.
doesn't say, for example, that the Public Service Commission can make recommendations to the government
Mhm.
or to the head of the civil service.
Mhm.
And then that point is then reinforced in 82(2) before they make recommendations to the governor. They're supposed to consult with the premier. Well, that didn't happen either.
But you say that the decision for that
This-
office, for anyone
Yes.
who is interested in being appointed to that office,
Mhm.
because we're not concerned with an appointment, we're concerned with the decision at this stage for a 6-month acting period.
It makes no difference, milady, whether it's an acting appointment or a permanent appointment. That doesn't make any difference.
Is it
There's
was that an exercise of disciplinary control?
No, milady, this is because it wasn't disciplinary because she never she never got employed, if I can put it that way, in the role. What
No, but it
happened?
says exercise of disciplinary control over persons holding or acting
Well,
in such
yes,
offices.
well, that's right, milady. They can. It makes it's quite clear, and I'll come on to it in due course.
Mhm.
This envisages both acting roles and permanent roles, if I could put it that way. There's no distinction drawn in this legislation between an acting role and a permanent role.
So the power to make appointments and to remove and or to exercise disciplinary control, that all relates to any person who is holding or acting in the office.
Yeah, well, yes,
That's
and
what
well, I'm concerned with the power to make appointments to public office.
Mhm.
That's what we're talking about.
Okay.
And you have to bear in mind, subsection 2
Mhm.
specifically says that that there has to be before you make the recommendations in relation to, in our case, the head of a department. The commission shall consult with the premier. We know that didn't happen,
Mhm.
but we should. The reason I'm also referring your ladyship to subsection 2
Yes.
is, and that's why I took you to 83(1).
Yeah.
There is no ability
To delegate.
to delegate. It stays when you're talking about head of department, that power stays with the governor.
Yes.
And what is purported to have been done, at least they were trying to do, is to have the head of the civil service make the appointment.
Okay.
They can't. There's no power to delegate, and it's just one of a number of errors, because that presupposes. Well, this is why you come back to the question, and the question has to be asked, in my respectful submission of my learned friend, Mr. Horseman, who were the Public Service Commission making these recommendations to? And if the answer is anyone other than the governor, why? They had no power to do that. That wasn't their remit. So what happens then, my lady, going back to the chronology, is the applicant was informed of the Commission's decision stroke recommendation on the 14th of July. And not surprisingly, the first thing she did was to send an email querying, if I can put it this way, the logic of that decision. And I'm looking at a paragraph 8 of our submissions, my lady,
Yes.
the bottom of page 3.
Mhm.
On the same day as the meeting, the applicant, that's where she was informed of this decision or recommendation, whatever you want to call it.
Mhm.
The applicant wrote to Eves, and I don't know if I'm pronouncing it right, Lorty, but if I apologize if I mispronounce it. And with Christopher Farrow, quote, seeking clarification with respect to the 6-month acting period proposal as the director of parks, and seeking confirmation as to whether a further 6-month probationary period will be expected at the conclusion of this acting period. The first thing that occurred to the applicant, not surprisingly, was to say, well, wait a minute, why am I getting 2 6-month probationary periods? No response, paragraph 9, was received, and the applicant sent further requests. And then eventually, over a month later, there was a response, paragraph 10, that the applicant would be appointed to act as director of parks, and after a 6-month period, the PSC would determine if it was satisfied that most of the issues had been addressed, whatever issues, they didn't share them with her, and if so, appoint the applicant to the post of director of parks with a further probationary period of 6 months to follow. That, in my respectful submission, is just a fundamentally irrational decision. What could not be accomplished in a single 6-month probationary period? And is as is accepted, there is the ability under the regulations to extend a period of probation upon a substantive appointment being made in any event. So moving on, the start date for the acting appointment. So this is all being done without the governor's involvement at all. So the start date for the acting appointment was the 1st of October. And she received communications in August that a training plan was being formulated for the end of that month. I'm down to, I think, paragraph 13 of my submissions, my lady. Mm-hmm. On the 10th of September, the PSC met again in relation to a letter from the acting permanent secretary, and he was detailing complaints, and we'll go into those when we deal with my learned friend submissions, and said they could not basically proceed with the appointment and asked the PSC to abort the recruitment process. Naturally, as was consistent all the way through, my lady, the applicant was not told of this report, not given sight of it, not given the opportunity to respond to it. But in any event, and very importantly, my lady, mm-hmm. the Public Service Commission declined that invitation. So they had this report setting out apparently all these complaints. They didn't give the applicant the opportunity to respond to them. But in spite of all those complaints that are appearing at the I can't even say 11th hour, it was after midnight. After all those complaints, the PSC declined the invitation or application to abort the process, and they pressed on with their decision to have her act for 6 months. And then if successful, then there would be a substantive appointment. Now that is important for a number of reasons, my lady. Later on, and this is a surprising submission that is made, well, it's in the evidence, but it's a submission that is made by my friend. There is an assertion made by the PSC that she was not of sufficient merit to warrant the appointment. If that assertion had any validity whatsoever, which we say it doesn't, they would not have pressed on with the decision to have her act for 6 months. What they did do, milady, as they were duty bound to do under the regulation, was to select the best candidate for the position. To now come back before this court, swear affidavit evidence, which is not supported anywhere in the minutes, and make submissions that she is somehow not of sufficient merit, despite the fact that that ministry unanimously recommended her for the post, is my respectful submission reprehensible. You don't go around slagging off people's reputations to try and make a bad point good. I'll come on to that later on. There then followed, milady, a period of basically obfuscation and confusion with permanent secretaries, acting permanent secretaries saying matters remained with the PSC when they didn't, and so on, until finally, this was batted back and forth, on the 5th of November, I think I am, yes, down paragraph
21.
21, well done, my lady, yes, thank you.
Mhm.
Paragraph 21. On the 5th of November, yes, there was a meeting with the new permanent secretary. And it was where he confirmed that there would be this, she would be acting for 6 months. And the permanent secretary had met with the PSC that same day, and the minutes make clear she was the best person for the job and had the support of the head of the civil service. And a new start date was given for the 10th of December. And then, my lady, rather, if I can ask your ladyship to read paragraph 22, it's a short one.
Mhm.
On the 13th, Mr. Rochester again wrote to the applicant, this time asking her to, quote, quietly speak with your director to advise December 10th is the proposed date you come across to start the 6-month acting per the decision of the PSC. And then on the 20th of November, the applicant met and signed off with the permanent secretary on what is called basically a development plan or a training plan. 3 days later, on the 23rd, the permanent secretary wrote to the PSC and they met on the 26th of November, wherein Mr. Rochester notified the PSC that he wanted to, quote, withdraw the application. And the PSC agreed and consequently withdrew its recommendation, such as it was, and to whoever it was, to have the applicant act. And the question must be asked, my lady, what happened in those 3 days? What happened in the 3 days before signing off on her training plan, and in fact, really 2 days, and then writing to the PSC to say we're going to withdraw the application, i.e., we're going to try and pull the rug out from under her feet? Simply put, my lady, we don't know what happened in those 3 days. But more importantly, perhaps, or just as importantly, could the application be withdrawn? And on that basis, my lady, if I can ask you, I'm going to jump a little bit. If I can ask your ladyship where I am now in my submissions is paragraph 46.
Okay, just give me a moment, please.
Certainly, my lady.
Yes, okay. We're at paragraph
I'm at paragraph 46, my lady. but-
46,
but
yep.
yes. So if I could ask your ladyship to turn to that,
Mhm.
and at the same time, if you could take up one of the hard copy documents delivered to you this morning,
Yep.
it's headed recruitment code,
Yes, I see it.
and make a couple of points in any event while I'm here.
Mhm.
Page 4 of that document, my lady. The recruitment procedures include, and then the last bullet point on that page, fair and objective selection and evaluation at each stage. We are going to submit, my lady, with clearest of authority, that where investigations are commenced and reports requested detailing complaints, and the applicant in this case wasn't given any information in order to respond to them, the simple concept of natural justice and fairness, namely audi alteram partem, comes into play. And as your ladyship is well aware, that concept is enshrined in our constitution. And if the point be in any doubt, if you can turn the page to page 5.
Mhm.
Additionally, civil servant recruitment procedures must be consistent with employment legislation, including the following statutes. And the first one listed is the Bermuda Constitution Order. Now, I make that point because, somewhat surprisingly, both my learned friends make the bold assertion that the Commission has the ability under its regulations to set its own procedure. But obviously, my lady, that must mean that procedure must be fair and consistent with constitutional rights. But that's the point is made good in any event in this recruitment procedure. So when you see those submissions by both my learned friend, Mr. Horseman, and by both my learned friend, Mr. Myrie, that in fact, my learned friend to the Attorney General basically makes the board, they can do whatever they like. I'll come on to his submissions on that point in due course. But the simple point is, no, they can't. They have to be fair. And making a determination based on complaints that our client never ever had the opportunity to respond to is obviously unfair. In any event, my lady, can I ask you then to turn page 6?
Hello?
Well,
I'm in a hearing. I can't talk to you right now. Let me call you back later on. I don't know how long it's going to be, maybe end of the day or something.
All right.
Okay? All right.
Brian, I think you're on your.
Oh, my apologies. Sorry. Let me tell
The joys of Zoom. So my lady, if I can ask you to look page 6, and I'm looking at section 7,
Yes.
the recruitment request. The permanent secretary, on behalf of the employing department, is responsible for ensuring that there is an operational necessity for the substantive vacancy to be filled. The employee, and then the last sentence, the employing department will, oh, sorry, I should also read that. The employing department must also ensure that there are sufficient monies available to fund the position. The last sentence, the employing department will also need to decide whether the vacancy is to be filled on a permanent, temporary, or fixed term basis. The next 7.1, it is vital to ensure that there is a business or operational necessity to fill the vacancy. So, the corollary of that, milady, is that you cannot, assuming that you have the funds, which there's no dispute here, you can't, and there is an operational necessity, there is a duty on both the government and the PSC to get that vacancy filled. What follows from that is you can't withdraw an application in circumstances where there remains an operational necessity. And that's basically what we're saying in paragraph 46. No doubt there was an operational necessity. If you look at paragraph 47, my lady, this shows, for example, the complaints being made by the BPSU in February of 2021, They need a substantive director, which is a priority to instill some stability. Department of Parks have been treated with total disrespect, with no less than 9 acting directors since 2016. Many of the acting directors had 0 experience. Not only that, milady, but it then goes on, or it's in our submissions, and it's not in dispute. That's in, I forget the date. What was the date of the re-advertising? It's in our submissions, milady. Subsequently, sorry?
December 2020.
It's in December 2020, milady. The government reapplied for this position to be filled. We wrote in January of 2021, raising the issue that she was the best candidate, etc. And perhaps no surprises, again, the application was, quote, withdrawn.
Yeah, that's all set out in your paragraph 46.
Thank you, milady. Sorry, I'm very grateful. Yes, it is. Thank you, milady. And so if you have 46, there can be no question that this was and remained an operational necessity. So there was no basis to withdraw. Sorry, let me put it this way. There's no proper basis to withdraw the application. The real basis was for the sole purpose of trying to prevent the applicant from holding the position that this ministry unanimously recommended her for. That, my lady, is, in my respectful submission, the epitome of illogical, irrational, abusive, and in breach of fundamental common law rights. So then we come on, which the point I've touched on, my lady, the question of can, in fact, the head of the civil service appoint directors for acting positions. That point is covered in paragraph 42 of our submissions. And I've already taken your ladyship to section 83 of the Constitution. The director of parks is the head of that department. There's no dispute. And consequently, the appointment must be made by the governor. And as I've already showed your ladyship, I don't think
delegate.
Thank you, my lady. You took the words right out of my mouth. You can't delegate. In addition, my lady, it's sort of icing on the cake at that point. It requires, before any recommendation is made, that there be consultation with the Premier. Oh, I should make, sorry, one point I think I should make as well, my lady, on the whether it's acting or not. Does your ladyship have, it was the other hard copy document, it's the conditions of employment and code of conduct. Sorry, my lady, I should have taken you to it just a moment ago. 3.2.5.
Have me in recruitment on page 14, maybe?
I'm looking at, sorry, 3.2.5?
3.5.2.
3.0, dyslexic.
Recruitment process.
Yes, yeah, well, I'm 3.5.2, the lady.
Yeah. Okay.
The following guidelines will be considered by permanent secretaries and heads of department when determining if an acting or deputizing appointment should be made. Permanent secretaries and heads of department have an obligation to ensure that an acting or deputizing appointment is absolutely necessary. And here they were, my lady, withdrawing an application that they had made, obviously because they were of the view that it was absolutely necessary. And it was allowed to be withdrawn by the PSC, presumably without demur. What the PSC ought to have done in the circumstances was to say, well, you made the application. What's the reason for you wanting to withdraw it? What is the valid reason for you wanting to withdraw it? Obviously, by the way, the reason that we want to stop the applicant from getting a job that we, a few months earlier, had unanimously recommended it for is not a valid reason.
Mhm.
So then, my lady, I would ask your ladyship, perhaps, the risk of being a little bold, that there are questions that both my learned friends, singularly or together, have to answer. One of those questions is, why have someone act as a director when they have already done so for the previous 10 months? Related to that, why have her act when exactly the same result could have been achieved with a substantive appointment,
The
i.e.
probationary
the
period.
probation? Exactly, my lady. Why did the PSC not make recommendations as required to the governor? And following on from that, why did they make them to either the permanent secretary or to the head of the civil service? Why do they allow the application to be withdrawn when obviously there continued to be an operational necessity? Why didn't the Public Service Commission give the applicant a proper opportunity to respond to the accusations made against her? And in relation to that, my lady, if I can ask your ladyship to turn that last question, turn to paragraph 38 of our submissions.
Yes.
And perhaps if I can just read it, because it is important. It was therefore surprising for the PSC to request a meeting with Mr. Farrow to discuss concerns they had regarding the applicant's managerial style. It is noted and of critical importance that having convened such a meeting, Permanent Secretary maintained his recommendation that the applicant be appointed and confirmed any concerns could be overcome. Indeed, his affidavit evidence filed in support of the government's position confirms that he was, quote, not personally aware of any issues with her that were insurmountable. He further confirms that he was asked if he was aware of, quote, the applicant's history, and states tellingly that the PSC may have been aware of other matters, but they did not share those with me. Accordingly, Mr. Farrow could not naturally comment on or refute any such concerns or advise as to the impact those issues may have pertaining to the applicant's ability to assume the role as director. Moreover, the applicant was never advised as to the nature of these other matters or what was meant by, quote, her history. Those concerns were never documented, and more importantly, the applicant was never given the opportunity to address the alleged issues. Any decision taken in this way, it is submitted, is clearly in breach of the principles of fairness and unlawful on that basis alone. Pausing there, here again it is submitted that it is axiomatic that these principles apply and must be respected and include the elementary proposition that persons must have an opportunity for effective comment on matters thought to be against them. The following particular points may, however, be made. And then, my lady, we're dealing with teaching ladyship to suck eggs, but the principles of adialter and partem and nemo judex and causa sua. And then the bullet points below, the general principles of fairness are as follows. First, the decision maker must give the person affected a prior opportunity to make recommendations, often by putting matters or allowing a chance to comment, the response then being conscientiously considered. This is the basic right to be heard. Here there is overlap with the duty of legally adequate consultation, the duty of legally sufficient inquiry, and the duty to take relevant considerations into account. Second, the decision maker must give the person affected sufficient information for the person to be in a position to make proper representations. This is the basic right to be informed. This aspect of fair procedure allows representations to be properly informed, eliminates unfair secrecy, and avoids the affected person later being unfairly taken by surprise. General principles of procedural fairness may supplement a statutory procedure depending on its particular provisions and the context generally. Notwithstanding all the above, the PSC purported to defer its decision and recommend that the applicant act for 6 months to assess whether her management style should be remedied. And at this stage, my lady, it's a little out of, I can ask your ladyship to pick up my learned friend, Mr. Horseman's submissions.
Yes.
I'm sorry, I have to smile. He's called it on the tram lines. It's labeled the second defendant submissions.
Yes.
Just noted that, but we don't have a second defendant. I think we should. I think he means the first respondent.
The first respondent, yes. Okay.
Yes, if you could make that correction. Thank you, Mr.
That's fine.
That's not.
I noticed that this morning myself.
Hopefully, that's not my best point. If I could ask your ladyship to turn to paragraph 40 of my friend's submissions,
Yes.
because this is how he deals with it,
Mhm.
or tries to deal with it, this issue. Mr. Rochester did meet and discuss the withdrawal of the post with the applicant. So this was after the fact. See paragraph 12 of his affidavit at page 145. Although this appears to have happened after the fact. However, the applicant was consulted, so he says, and still had the opportunity to persuade the PS to change course. But it is clear that given the circumstances, the PS would not do so. This is reinforced in Mr. Rochester's affidavit evidence that this was an obstacle that could not be overcome, and he was not going to expose the government of Bermuda to a potential labor withdrawal. So the response of the PSC to clear breaches of the duty of fairness, first of all, is unfortunately to try and foister that responsibility onto the permanent secretary. It was their duty, not Mr. Rochester's. But then more importantly, go and say, well, actually, it didn't really matter because nothing, the die was cast. There was nothing they could have done would change the mind. Amazingly, milady, you should note, by the way, I'll come to it later, it's in the evidence, that she has acted as director, not of this department, but of the department where she works, no less than 5 times since then. So clearly she is a fit and proper person. She is of sufficient merit to do the job. And interestingly enough, there wasn't a massive labor withdrawal. I think my friend puts it rather dramatically at the earlier paragraph, a wholesale mutiny on its hands. That didn't happen in any of these 5 times. But the point I'm making in any event while I'm there, why I took you there, my ladies, to say that the PSC's response is, doesn't matter. She'd be gone anyway. Nothing would have changed the permanent secretary's mind. Begging the question, of course, is why didn't the PSC ask these questions?
Yes.
So in any event, my lady, as I said earlier, the PSC ought to have recommended her, we say, for the substantive position to the governor, instead of relying on secret, undisclosed accusations garnered by the PSC. As I've said, there's no doubt that she's the best person for the job. The interview panel, comprised by the government, unanimously recommended her out of 22 candidates, and she was the only one they recommended. And if the real reason, this is coming back, sorry, my lady, I should just touching on the point I made earlier, and I made it slightly out of turn. I'm going to come to this in my dealing with my friend's submissions, that their assertion that she was not of sufficient merit. And the simple point there, the very simple point is, as I said earlier, if she wasn't of sufficient merit, then why would you appoint her to the post for 6 months to see if she, and then if she successfully did it, performed that role, then to substantively appoint her? It's not consistent. If the real reason, which we say wasn't, was that she was insufficient, she was of insufficient merit, then why not simply not recommend anyone to the governor in accordance with your statutory duty? All they had to do was to write and say to the governor, with reasons, of course, that we've considered the sole recommended applicant and we've decided not to make any recommendations. What they've done instead, realizing their various blunders, is a poor attempt at ex post facto rationalization. Made all the more egregious that they clearly have no problem sullying someone's reputation, as I said earlier, in the hope of making a bad point good. It's disingenuous. It's actually should be beneath the PSC. And in my respectful submission, my lady, this type of behavior and conduct should color all of their evidence and all of their submissions. Your ladyship should also note, amazingly, that there is, with the exception of a report, which we'll come to, which my client never saw, there is not one scrap of paper or email or letters or minutes of meetings detailing all these discussions that the ministry had with the unions. Made all the more surprising that there was even a letter, my lady, that was referred to in the minutes from the BPSU to the acting permanent secretary and copied to the head of the civil service. We asked for a copy of that letter and it can't be found by anyone. And one wonders why. And why is there this dearth of information, recorded information, concerning a crucial issue, at least crucial according to the PSC and the ministry, on these discussions? We would say, in addition, my lady, that there's no doubt of a legitimate expectation. She was the only candidate proposed. She had assigned a training, assigned an agreement for her development process. She had acted for 10 months prior, and there was nothing to suspect that she wouldn't succeed. Now, those are my sort of general observations on our submissions, but if I can take you now to some of the documents, my lady. So if you could pick up, firstly, the pleadings bundle.
Yes, let me just clear what's in front of me for a minute.
Yes, sir. Oh, I should say for the record, my lady, in case there's any confusion, I don't think it was my learned friend, Mr. Adams, is sitting next to me off camera on the right. So he is appearing as well with me in this matter. So
Mr.
Mr. Richards, my lady.
Mr. Richards, yes.
Yes.
Oh,
So
Miss
if you-
Adam Richards, yes.
Yes,
okay.
my lady, yes. So if your ladyship sees,
I did see his name.
oh, yes,
um,
features
amongst the
prominently in all
documents,
this.
So I did
Yes,
intend to. quote both of
sorry,
you.
I should,
Yes.
yeah, thank you, my lady. Can I ask, does your ladyship have the pleadings bundle?
Yep.
Could I ask your ladyship to turn firstly to page 36?
36.
Yes, my lady. It's a letter dated the 9th of July.
Yes.
To the acting permanent secretary from the PSC. So this is after the meeting of the 2nd of July, where this issue of management issues first seemed to raise its head. So at its meeting held on Monday, the 2nd of July, the PSC met with Mr. Farrow to discuss the recommendation to appoint Mr. Lynn Thompson to the post of director. Based on the commission having information on a previous matter between the recommended candidate and an employee, Mr. Farrow was asked to share feedback regarding Ms. Thompson's managerial style and her suitability. Now, what on earth is that? On a previous matter, I mean, you cannot get more cryptic. On a previous matter between the and an employee, he was asked to share feedback regarding her style and her suitability. Remember, and I'll come to it, Mr. Farrow wasn't given any details as to what this was about. He indicated while he was acting permanent secretary, he was aware of some of the challenges Ms. Thompson had faced, including employee feedback and union matters. Mr. Farrow, however, indicated he believed these were challenges Ms. Thompson could overcome. As a result of the discussion with Mr. Farrow, in conjunction with information shared previously, no idea what that is, the commission felt having Ms. Thompson act for a period of 6 months will allow adequate time for the head of the public service to ensure the acting permanent secretary assess the challenges related to Ms. Thompson's managerial style and whether they can successfully be assessed and remedied. Nothing to do with the governor. During this period, the commission requested 2-month assessments signed by the head of the public service, acting PS, and Ms. Thompson provided them to review. Then, interestingly enough, also the commission agreed to defer a decision on the appointment to the post of director. Nothing about recommendations, and this is the secretary to the PSC writing, until after Ms. Thompson completes the 6-month acting period and the assessments have been reviewed. Then if I can ask your ladyship to yes, if I can ask while I'm there, over the page to 37.
Yes.
This is a letter from the permanent secretary then on the 23rd of November. This is when Mr. Rochester was now the permanent secretary. It says, you may recall at the, well, that's a typo, it should be November 5th meeting. Had to be November the 5th meeting with the Public Service Commission. I committed to meeting with the respective trade unions regarding the possibility of having Ms. Lynn Thompson act as a director of parks for a period of 6 months while on a development plan. It was my view from these discussions, no minutes recorded, that my approach was acceptable and I would have the support of the unions based on the plan to work with Ms. Thompson through the challenges that were raised prior to my coming in the ministry. Somehow this information has found its way into the rank and file. To that end, it has become increasingly apparent over the last week that bringing her on board in any capacity will be very contentious. And I've been made to understand there's even a petition circulating, hasn't seen it, among the Parks Department that's raised some 80 signatures in protest of Ms. Thompson's acting. Therefore, I'd like to withdraw the application for the post of director, Department of Parks at this time until further notice. I have conferred with the head of the public service who has no objection to this course of action. So no reason given. The reason is inferred. We just don't want to give it to Ms. Thompson. But no mention, of course, operational necessity and so Then, my lady, if I can go on to page 39.
Mhm.
This should be an email from Mr. Rochester to the applicant. And it sets out the agreement, and you will see how she was not provided any opportunity to respond or address the concerns. This is what he says. I think just making sure I get the yes. If we can perhaps go from 11 to the so we take it in order, milady. So halfway down page 39. Let's deal with Miss Thompson's email first at 11:15 a.m. Good morning, P.S. Rochester. On the heels of successive meetings with you in discussion with my placement at the Department of Parks as acting director scheduled for December the 10th, and with the following probationary period for the Director of Parks post as per the PSC recommendation, I would like to request the reason for the withdrawal of this offer. When we met this Monday, you informed me that you had bad news and that I would have to stand down. You proceeded to talk about how the situation has escalated. However, the exchange was obscure. The particulars of the matter were not disclosed. And from the bits and pieces shared, I recall responding to you that it sounds like there's a lot of drama, and you agreed. I was not given any specifics as to what had transpired, and it was not clear how this outcome was any fault of mine. It remains unclear to me why the offer to act as Director of Parks was withdrawn. And again, I seek your response for clarity. And then it goes on about we met at my substantive department, and among things discussed, my 6 months acting, professional development plan, some of the issues. And then she goes on Tuesday, the 27th of November, I received a generic response from the Department of HR, thanking me for attending the interview in May for the director post and informing me that I was unsuccessful in securing this post. Well, it wasn't unsuccessful. They pulled the rug out from underneath her feet. And then Mr. Rochester responds at 5 o'clock by saying, thank you for your detailed email below. The short answer is the issues raised prior regarding your approach, lack of confidence, trust, abrasiveness, talking down to staff, etc., was something I thought could be worked through, hence my efforts. However, as these issues appear insurmountable, the acting opportunity was withdrawn. So all these issues that he lists, for the first time, 30th of November, after 3 days earlier, she'd been told that she was unsuccessful, and now being told, you know, your ladyship has the point. At page 62, my lady.
Yes.
I'm just going to take you to it very quickly. You will 62, 63, you will see is the professional development plan that she had agreed to. For your ladies, hopefully for your ladyship's assistance, at tab 11, if your ladyship wants it, there's our client's fourth affidavit, which my respectful submission does set out a rather helpful synopsis of the revised case.
Thank you.
Page 113. Yes, this is at, yeah.
Sorry, I'm
Yes.
looking at page 62.
Oh, sorry,
Can you
Marty.
just give me a
Yes.
different page number?
No, I'm now taking you, sorry, my lady, I'm going a bit too fast, I apologize. Can I ask your ladyship to turn to page 113? 62 and 63 would just so you could see.
Oh, I see, just, okay.
Just so
Thank
you understand what this
Yep.
development training plan, it's comprehensive, and it was agreed to 3 days before Mr. Rochester decided to applied to the PSC to withdraw the job application.
Thank you.
Page 113, my lady, paragraph 8. This is the affidavit, the second affidavit of Miss O'Brien.
Yes.
And this last sentence, the PSC were not satisfied at the time of deferring of the decision that the applicant was of sufficient merit and fit for the post. I'll make the simple point. I'm quite happy to challenge my friends to show me where in any of the minutes there's any mention of her not being, or concern of her being not fit for the post. That is the most disingenuous comment or statement to make. It lacks any evidence to support it and is in fact inconsistent with their decision to appoint her on an acting basis, which would be made substantive upon successful completion. Page 137. This is the affidavit of Mr. Farrow.
Yes.
I think, unless my friends want to, I'm going to pick it up at paragraph 5, unless my friends want me to read anything else earlier to that. Ms. Thompson was acting director of parks at the time, and I had been appointed by former P.S. Richardson. While I was acting, the BIU shop stewards met with me on a number of occasions to raise concerns about Ms. Thompson's management style. Examples included her being disengaged during JCC meetings and spending time on her phone. The Government of Bermuda hiring process calls for an initial vetting by HR who shortlist applicants for further consideration and interview. No performance issues were raised by the Department of Human Resources, I think of which Ms. O'Brien is also the head of.
Mhm.
So no were raised about Ms. Thompson, and for my part, I was willing to overlook the reports I had received from the shop steward, as the Parks Department had been without leadership for too long and was in need of stability. So if I can put it this way, operational necessity.
Yes.
I did not consider the reports from the BIU to be of such a nature that would lead me to believe that she was unable to manage the department. And I think I can. Then then follows the lady. There's a Mr. Farrow discusses. There was a rather, if I can be quite blunt and say, a sort of intemperate exchange from Ms. Thompson, paragraph 8. She was very upset about her acting appointment not being extended. Appeared at my office unannounced with a colleague in tow to confront me about her not being extended in the acting role. She also wrote at the time to the head of the PSC demanding a meeting to find out why she was not being extended. Then he said paragraph 9. Second sentence, I offered personal advice to her stating that during your career, you may be asked to step up to assist and you should do so without more than any expectations, the opportunity to show your abilities. And once the acting was over, you should go back with grace and be known as a go-to person. She, last sentence, appeared to take the advice well, and that was the end of it. The post was subsequently advertised, and I spoke with Ms. Sherry Witter, the deputy head of the civil service, and asked if the recruitment could be delayed until a substantive PS was in place, as I did not think it appropriate for me to be picking a management team for them. She told me to get on with the recruitment without delay, operational necessity. 4 shortlisted applicants were interviewed for the Director of Parks post, and that sets out who were in the panel. Paragraph 12, Ms. Thompson was unanimous choice by the panel, recommended to the PSC. As I've done in the past with recruitments that I was leading, I called the recommended applicant and advised that the panel was recommending her to the post. But ultimately, it was the PSD's decision. There was no guarantee she would be offered the post, and they may interview. It would also require the governor's approval. At least Mr. Farrow's got it right. My acting appointment ended before the matter was concluded. I went on leave. Mr. Lorty took over the acting appointment and I did not act again as PS. On return some 4 weeks later, I was surprised to find that the post had not been filled and was asked by the PSC to attend a meeting with them. At the meeting, they questioned why Ms. Thompson was recommended and if I was aware of her history. I had not seen her personnel file and could only go on the experience I had with her in the interview. I did advise them of the issue I had with her acting appointment and not being renewed, but her response to my advice was well received, and in my view, the matter was closed. I was personally not aware of any issues with her that were insurmountable and advised the PSC as such. It appeared the PSC may have been aware of other matters, but they did not share those with me. Then if we can go to page 143, the affidavit of Mr. Rochester. Yes, this is rather curious. Paragraph 6, sorry, 144. On September the 13th, I received an email from Ms. Thompson who requested an update on the status regarding her acting appointment to the Director of Parks position. Not unreasonably, lady, this has been outstanding since May.
Yes.
I responded advising it was my understanding that the matter was with the Public Service Commission. Now, why? 3 days earlier, the Public Service Commission had told Mr. Rochester to get on with it. There had been an application to abort, you might remember the wording, to abort the process. And the PSC had said, no, she's going to do an acting appointment, get on with it. So why would Mr. Rochester say that the matter was with the PSC? They'd made their decision. Over the ensuing weeks, I was approached by many staff from the Department of Parks who expressed concerns consistent with the concerns mentioned above, that if Ms. Thompson were to be appointed to the post, there would be a walkout of the employees. Sometime around the first week of November, I reached out to Ms. Thompson to schedule a meeting to provide her an update. That meeting, I recall advising Ms. Thompson of the concerns raised by staff, but at that time, I believed I could manage the staff by working with her during the 6-month acting period, which was to be a development period. However, I did not advise Ms. Thompson that she would be appointed to the post, as this was simply not my decision to make, but I advised her I'd make a recommendation to the PSC after the acting period had concluded. So this was early November.
Mhm.
I'm sorry, Malay, just checking my notes. It goes on, at this meeting, I advised not to share the details. It would be more difficult for me as a new permanent secretary. 10, during the month, met with the union members on 2 occasions to discuss the possible appointment. Both meetings, I was vehemently reminded of the concerns about Ms. Thompson's leadership style and how the staff felt intimidated by her. I was reminded that there would be consequences if she was appointed to the post, which in no uncertain terms meant a walkout of the staff of the department, which could escalate beyond. As a result of these concerns expressed by staff regarding Ms. Thompson being appointed to the post, that I determined this was an obstacle I could not overcome. Interesting choice of words, because Mr. Farrow used almost exactly those words, saying there were obstacles that he believed they could be overcome.
Mhm.
I was not about to expose the government of Bermuda to potential labor withdrawal. Note, she's acted 5 times since then without union action. Page 145. Sorry, my lady. The application was I've taken you through that. And then, my lady, 149. This was the for the BPSU, stating how important it was that they get on with, how important it was that it be a permanent appointment. It's a bit ironic that the BPSU, who basically appeared to have caused a lot of this issue, is now complaining about there not being a permanent post. Then, my lady, can I ask your ladyship then to take up the correspondence file?
Yes.
This is the letter of recommendation from the interview panel, Mr. Farrow, to the PSC.
Sorry, just while you're doing that, Mr.
Yes.
Myrie, can I ask you, because I find it odd, I have not come across your written submissions. I don't know what I've done with them. It's a bit of a mystery to me, I have to say, but can you just email them to Ms. O'Connor, please?
Yes,
So that by the time I get to you, a reprint is in front of me.
yes, I will do.
Thank you very much. Yes.
So just-
And Mr. Dill, since I've interrupted you, I'm conscious that no one's had a restroom break. Is there?
Yes,
A
Yes,
point
yeah.
which is
this
convenient?
this is as good a place as any, my lady.
Okay. Unfortunately, I'm going to have to ask for an extended one because I have to move my car. And so that's probably going to require a 20-minute break. And we should not come back until 12, maybe even 12:05.
12:05, my lady?
Okay. All right. Thank you.
I can just put you guys in the waiting room. So you don't have to leave and come back.
Doing the best I can, Richard, as fast as I can.
You're doing well, Mark. I mean,
Doing as I promise I'm making best speed.
yeah. I'll make a recommendation very soon for you.
Your ladyship's muted.
All right, that should be good.
Yes.
Yes, thank you.
Thank you, my lady. If we can press on. If I can ask you to take up the correspondence binder. And I'm asking you to go, if you could go to page 5. This is the letter. I think this is a letter of recommendation. Please don't put the pleadings bundle too far away, because there's one matter I do want to go back to on that.
Okay, it remains
Sorry.
open in front of me.
Thank you, my lady. Did I do page 5?
You went up to.
I did. I don't.
This is the 16th of May
Yes. my lady.
letter. You have not referred me to this.
No, I haven't.
Okay,
Don't. Mr. Richards throwing me off my stride.
Maybe you had some discussions about it, but
He's done very well so far. So 16th of May, page 5, my lady. Letter of
all right,
recommendation.
sorry, Ms. O'Connor's trying to get my attention.
Oh,
Okay, all right, thank you. Yes,
So results of the interview are as follows. This is Terry Lynn Thompson recommended. You'll see she meets the educational requirements, approximately 20 years relevant senior management experience, inclusive of various relevant lengthy appointments as the head of department level. The most recent acting appointment being Director of Parks post for 9 months from July 2017 to April 2018. So at the time, so literally ending just before this letter was written. Ms. Thompson delivered an excellent presentation. She scored the highest of the applicants. She clearly articulated her vision and strategic plan for ensuring the mandate for the creation, implementation, and maintenance of the National Parks Plan would be met. She also had a very good interview. She provided in-depth responses to all the interview questions, and she was able to demonstrate her knowledge, experience, and passion within the field. She also scored the highest for the interview. And then over the page, you'll then see the last line. Panel unanimously recommends Ms. Thompson for the appointment to the director post. No mention of anyone else at all. And if I can ask you to go to page 15.
yes,
So this is the meeting held on the 21st of May.
Mhm.
And it recites the results of the interview. And then, so despite all this, so unanimous recommendations, etc. over the page at page 16, the last, but for no reason whatsoever, they agreed to defer a decision and requested the acting permanent secretary meet with the commission to discuss the recommendation.
I don't see that.
Oh,
I'm
last-
looking at page 16, last.
Page 16, very last paragraph, my lady.
Oh, I see, sorry.
Yes,
Okay, yes, thank you.
thank you. And then over the pages to 18, this is the next meeting on the 2nd of July. 1, 2, 3, 4 paragraphs from the bottom.
Yes,
So based on the commissioner having information on a previous matter between the recommended, again, cryptic, mysterious, no mention of it, who, what, when, no details. So something that was known only to to the PSC, certainly not to Mr. Farrow, and definitely not to the applicant. And curiously, at around this time, lady, we're now going to take your ladyship at page 26 to some performance appraisals of the applicant. It starts at page 26, and I think the relevant section is page 35, I think that's right. So I'm looking at I'm looking at Mr. Richards.
Second one, first one.
It's the first one. Listen, just look at quickly at 35. Ms. Thompson has had a very interesting year, first being the acting director of the Department of Environment and Natural Resources, then on to the Department of Parks for the remainder of the fiscal year 2017 to 18. As a consequence only of the officer's self-assessment has been entered, the officer did not formally report directly to me. This is Mr. Czar. I can say the officer did seek advice routinely as a colleague when needed. I'm aware of much what was outlined above and agreed with the substance as written. Then relating the next performance appraisal at 42. Now this period is from April 18th to March 19th. So if I can put it right around the same time as all these problems were, apparent problems were being raised by the unions, this is what her performance appraisal did. And at page 53, this is what Mr. Pettit had to say about her. Ms. Thompson continues to work well and is a valued member of the team. She's competent and well-rounded and conducts the responsibilities of the plant protection section with a high level of expertise and professionalism. As an example, Ms. Thompson and her team have tried extremely hard, going above and beyond to try and find a solution to the ongoing banana importation issue. This has included working closely with local importers as well as overseas agencies to try and assist with importation to import clean produce. Unfortunately, this unexpected issue has taken up a lot of time and energy, resulting in other projects not advancing as much as hoped. And then over the page, page 54, top of the page, Ms. Thompson works well with colleagues. She's always willing to assist and goes beyond the call of duty to deliver results. Ms. Thompson, this is going down the page, very good with our customers and always represents this department well. Ms. Thompson encourages the involvement of others in making decisions. She solicits collaboration of efforts to facilitate reaching comprehensive results. She provides sound advice on plant quarantine matters which can be incorporated into policy decisions. Page 56. Continues to perform her duties very well with expertise and dedication. I'm very pleased with her performance. Ms. Thompson continues to work well and is a valued member of the plant protection team. Ms. Thompson is a suitable candidate for upward mobility. None of this ended up in front of the PSC. Had the PSC bothered to comply with their obligations under the Constitution to be fair and afford the applicant the basic protection of law, i.e. at the concept of audi alteram partem, doubtless the applicant would have furnished them with her most recent performance appraisals. I'd also ask you, ladyship, to go back to on that point, to go back to the pleadings binder, because one point did occur to me when I was looking at this, and this is tab 9 of the pleadings binder. It's the affidavit of Dawn Santucci Smith.
Yes, I have it.
Yeah, I'm grateful, who was working at relevant time at the Parks Department. She doesn't have a lot of nice things to say about the Parks Department. She describes it as an unhealthy and toxic environment. for someone that actually wanted to work. That's paragraph 5. Unfortunately, the department was generally non-productive and quite dysfunctional. And the reason being, she says, is that they had not had the benefit of a formal permanent director for many years. I saw, paragraph 6, firsthand that the applicant was trying to remedy that position. She was passionate about her job and loves to work. She's definitely a leader. She would make clear her expectations from those that work for her. I had no qualms at all with that approach. It was definitely needed within the Parks Department at that time. The applicant will provide you with a clear directive and you'd be expected to meet the task. This would never be anything more than what was expected from your job description. However, there were clearly those within the Department of Parks who took an issue with being simply asked to do their job. It became clear to me that the lack of previous stable and consistent leadership of many employees in the Parks Department were used to largely doing whatever they wanted whilst at work. The applicant sought to make them responsible and expected that when tasks were issued, they would be completed accordingly. This did not seem to be an unreasonable request in my view. Approximately 2 years ago, in September 2018, I was entering the Parks office when I was approached by the receptionist. She asked me to sign a petition opposing the appointment of the applicant to the Director of Parks role. I asked what was the purpose of the petition, and I was told that they opposed the applicant getting the job because, quote, she will want us to work, and that, quote, she expects too much. I asked if the applicant had ever asked anybody to undertake work which was not in their job description. The receptionist could not identify any occasion that this had occurred, and I recall saying something like, if the task is within your job description, then it needs to be carried out. As such, I refused to sign the petition. I was told very clearly that having refused to fall in line, that I would be on their unpopular list. Yeah, thank you. Unpopular list. She goes on, the whole cause surrounding the applicant is, in my view, a very unfortunate situation. Department required the perseverance and leadership of someone like the applicant to resolve long-standing issues and dysfunctionality. He had passion, skill, ability. I have no doubt the applicant would have significantly improved the efficiency and structures by holding the employees accountable. So here is the flip side, if I can put it that way, to the coin. And it was a flip side that the PSC didn't bother to ascertain. They got one side, they kept it to themselves and acted on it to her detriment and didn't give her any opportunity at all to provide this type of information so that she would have at least a fair hearing. More on that later. Then going back to the correspondence binder, the lady.
Yes.
Yes, page 62.
Yes.
This is a letter from us to my learned friend, Mr. Horseman, because we had not had, we didn't know, and we still don't know who this former employee was. And we asked to provide minutes of the March meeting where P.S. Richardson appeared to address the probationary report and the unsatisfactory performance of an employee during the said employee's probationary period. And the employee's, this over the page, and the employee's allegations in response to the findings as detailed in the probationary report. So that was all, this is what the PSC were talking about, apparently. So then we do get a copy of the report. That's page 65. And I'll ask your ladyship can scan it. It goes over to page 66, but perhaps you can take it from me. My friends can jump in if they disagree, but there's absolutely nothing of concern at all in that minute. It's redacted, but there's nothing to deal with this issue. Page 70, is what we're doing, my lady, in this, we're trying to get to the bottom of all this because our client and us had been excluded. We were not kept in the loop. Neither was the applicant wasn't kept in the loop. So at page 70, we write in May, paragraph 1, please provide a copy of the minutes of all meetings with the union where our client's appointment to the position Director of Parks was discussed. In addition, the same minutes confirm that an official letter was received from the BPSU, which was copied to the head of the public service. Please provide a copy of this correspondence. Nothing happened. So in July, we write, repeating the request. Is there anything in there? There's nothing specific to the tendency.
Did you respond by email?
Yes.
Yes.
Yeah, but then, they and then we get a response on the 23rd of July, it's page 74.
Yep.
So if you go down the numbered paragraphs, please, where we ask for, please provide a copy of the meetings with the unions, there are no minutes. In addition, same minutes confirmed an official letter was received. There was no correspondence copied to the head of the public service that we are aware of. Well, somehow it found its way into BPSU, sorry, into the PSC minutes. Meetings as mentioned in the affidavit of Mr. Rochester. There are no minutes of these meetings other than what has been provided by the permanent secretary. So these are crucial meetings held in the absence of our client, and no one bothered to take a single note. There's not a single email. There's not a letter. There's nothing. We write back, page 76, I think, saying basically this isn't sufficient, and sort of redouble your efforts. It has to be there. Page 78, response from the AG's chambers, my learned friend. And it says we simply repeat what we said earlier. There are no documents, or we can't find them, which is extraordinary. Now, if I can take your ladyship through the submissions of both my learned friends, if your ladyship could take up my learned friend Mr. Horstman's submissions, I'll deal with his first.
Sorry, just before we pack that away.
Yes,
So
of course.
page 79 is unrelated to the
Sorry.
response from Mr. Murray of the 27th of August. Are these completely different documents? These acting appointment printouts?
This was a printout of who acted when, I think.
Okay, all right.
It's confidentiality.
Those are separate.
Yeah,
I don't need to confirm my-
yes, it's sorry, yes, I'm grateful to my friend. It's dealt with in the letter. It says, I refer, our records show that your client has not acted as Director of Parks since April of 2018.
Okay, so these were enclosures to the letter?
Yes, these are enclosures to the letter.
Okay,
It's confidentiality is director for substantive.
Yes, it's confirmation she acted as Director the 5 times since this episode, my lady.
okay, thank you.
I don't think that's it. I don't think it's in dispute.
All right, okay.
And if I can go now to my learned friend, Mr. Horstman's submissions. Paragraph 4.
Can I put away the correspondence binder and the
I
pleading binder?
hope so, my lady, yes.
Right.
And some of this is going to, I apologize, but some of this is going to be slightly repetitious, but I'm going to try and take it at a gallop.
Fine,
Paragraph 4, my lady.
yes.
As set out in Mr. O'Brien's, the PSC had concerns about the applicant's managerial style and decided to defer the decision with a view to reconsidering. It wasn't just on the 2nd of July, my lady. They also did it on the 5th of November.
Mhm.
So it wasn't just the 2nd of July where this quote decision was made, and you'll see my learned friend refers to the decision. Then he says the last sentence, the PSC, sorry, deal with the first sentence. One other point, it deferred the decision with a view to reconsidering the matter at a later time. And one must ask the question, why? They already have the 6-month probationary period set out in the regulations when there's a substantive appointment in any event. So why? Second sentence, the PSC recommended that to whom, not the governor. Then paragraph 5, the applicant impliedly submits that the PSC had no power to defer the decision and was bound to appoint the applicant. And our point on that is it's not quite our submission, my lady. We make the point that the only logical, rational decision in relation to someone who was unanimously recommended, and there was no proper reason to defer the decision, should have been substantively appointed at that time.
Mhm.
And the recommendation ought to have been made to the governor at that time
Mhm.
to appoint her. Paragraph 6.
Compensation to the premier.
Your ladyship has the point. Indeed, none of that happened. Hence, that was my list of questions that you might remember before the break. Paragraph 6. My friend has it right. The PSC could only make a recommendation to the governor, and it would be for the governor to actually make the appointment. Totally agree. Did it happen? We know from my learned friend for the Attorney General's submissions, and is accepted, it didn't happen. Paragraph 7, the PSC is not a rubber stamp. We're not suggesting that they are a rubber stamp. My lady, that's about, the emotive language aside. Then it goes on to say the PSC is an independent body. It's free to regulate its own procedure. That was the comment I was making earlier. But my lady, we don't quarrel with that assertion. It is free to regulate its own procedure, but it has to do so subject to the rules of natural justice and fairness, and so that it is compliant with an individual's constitutional rights of protection of law. Yes, and then bottom of the page, the PSC is not simply a rubber stamp, it's entitled to rely on its own experience and knowledge when considering appointments. It can, we don't quarrel with that, but it has to do so again, consistent with the rules of natural justice. You cannot keep secret investigations about an applicant from an applicant and not give them the opportunity to respond to it. Then there are no provisions in the regulations or the Constitution which mandate that the PSC must make a recommendation within a stipulated period of time. Again, lady, the protection of law point requires it to be done within a reasonable period of time. So I'm not quite sure the point my friend is trying to make there. So this then says, so the decision to defer the consideration of the application was a decision open to the PSC to make, provided it is rational and logical. And it clearly wasn't in this case. Paragraph 9. Ultimately, and my friend's got it right again, as far as the procedure is supposed to happen, this is the third sentence. Ultimately, it is the governor to make the appointment after receiving a recommendation from the PSC. Did that happen? And then, I think, citing me as authority, The applicant's counsel has made the point in previous cases that it is the PSC's duty to consider all applicants in accordance with Regulation 19. Totally agree. Regulation 19 makes it clear that the PSC is not bound to appoint the sole candidate recommended by the PS or the interview panel, and then sets out the section where it says the commission shall consider all applications. Well, did they? There's no evidence that they did. So I'm not sure what the point of citing Regulation 19 is. And by the way, on the timing point, it shall consider all applicants within the reasonable time referred to in Regulation 12. So there is a time limit. And then goes on to say, shall, mandatory, if there is a candidate of sufficient merit to enable it to do so, make a recommendation to the governor. Did they? Regulation 14 also demonstrates the PSC can conduct its own inquiries in order to determine whether the applicant is fit and qualified for the position. Regulation 14 states as follows: the commission may require information. And then it says the commission may require any applicant to submit information, attend for interview, examination, tests, and whatever. So what did they do in relation to the applicant? Well, Lynn and Friends relies on this regulation. They kept everything from the applicant was the one person they kept in the dark. Well, Mr. Farrow too. But how does Regulation 14 assist him? Because they didn't ask the applicant to do anything. Then 11, the applicant submits that in the circumstances, the PSC had a duty under Regulation 16 to recommend her for the appointment as she was a candidate of sufficient merit. Of course she was. She was unanimously recommended by the panel, who were the ones who ought to know. The applicant suggests that Part 4 of the regulations has been complied with. As set out in Mrs. O'Brien's affidavit, the PSC had genuine concerns about the applicant's managerial style, which were in fact borne out, this is very interesting, by the report received from acting PS Lorty, who reported back to the PSC. So that's an interesting turn of phrase. So the PSC, according to my learned friend, we don't know this, but it seems to be clear from his submissions, tasked the acting PS to go and do a report to dig into the background of these allegations, and then secretly report back to the PSC and keep that from, and kept it from the applicant. Who reported back to, do we have a copy of that letter of the 29th of August? No. So then we have, who my friend says, who reported back to the PSC in his letter of the 29th of August. Where is this letter? That he had not received any positive comments on her management practice, but rather the comments he received, unprofessional behavior, talks down to staff, bullying, unwilling to listen, talks derogatory in a derogatory fashion, leadership style with autocratic, no team spirit at all, basically contradicts everything that is said in her performance appraisal, which was done at the same time. Now, the timing of this is important because that was done on the 29th of August.
Yes.
Your ladyship will remember on the 10th of September, so that's the application to report. Yeah. On the 10th of, sorry, I'm just making sure I got the dates right in my own head. On the 10th of September, that was the date where Mr. Rochester went before the PSC and asked them to abort the process. And the PSC said no.
Yes.
I think that, if you look for your ladyship to know, because I think it's important. Yes. Yes, that's it. If you read paragraph 13 of our submissions deals with that.
Yes, I did make a note when you dealt with
Thank
it
you.
earlier.
Yes, so the PSC had this report, which they had commissioned. And despite that report, and despite the application from Mr. Rochester to abort the process, they said no. So clearly the report didn't feature heavily or at all in their thinking. Paragraph 12. The acting PS further reported that the issues are severe and 100% of the comments he collected were negative, very strongly negative. Did he actually bother to look at her performance appraisals? Clearly not. He concluded that he thought that the applicant, as opposed to Mr. Pettit, you remember, who the point said, should be basically destined for greater things, after completing a successful training program, has the potential to be director of parks, but the present timing is not good. So even after all that, the acting PS says, I think she can still do it. And you'll note, by the way, this is exactly the opposite of what Mr. Farrow said to the PSC. And Mr. Farrow was on the interview panel. And my friend, quite rightly and fairly, essentially concedes this point because he says at paragraph 13, despite the negative feedback, the PSC decided it would stand by its previous recommendation for the applicant to act for a period of 6 months. So by doing so, they determined that she was of sufficient merit.
Yes.
Paragraph 14, to make the point, the lady again, that she, if she had a substantive, doesn't deal with the point at all that if she had been substantively appointed, she would have had a probationary period anyway. There's no answer to that. In fact, there's no answer to a lot of what we say. Then, so despite what's said in paragraph 13, we then unfortunately move to paragraph 15. Prize shall not recommend a person for appointment to an office if he's not fit to be appointed. But they did exactly that. The applicant argues that under Regulation 16, the PSC had a duty to appoint as she's a candidate of sufficient merit. It is debatable, they say, whether the applicant could be considered of sufficient merit. But the point is, it was for the PSC to determine whether the applicant was of sufficient merit. They had determined that, my lady, by their very actions.
Mm-hmm.
It is not for this honorable court to substitute its own opinion. You don't need to. The PSC's concerns were borne out by acting authority's assessment of the applicant, and a good argument can be made out that the applicant was not of sufficient merit. No, it can't. And it doesn't lie, respectfully, in my friend's mouth to even run this argument, given that his own clients had recommended her for the post. PSC had genuine concerns that the applicant was not fit for the appointment. Where is the evidence of any of this? The only evidence, it doesn't show up in any of the minutes. The only place it shows up, conveniently, is in Ms. O'Brien's affidavit, where it just appears out of nowhere, with no documentary evidence to support it whatsoever. Paragraph 19, the applicant also contends it was irrational and illogical because the applicant would have undergone the process twice. If substantially appointed to the post, the applicant would have had to serve a probationary period. As the PSC was not satisfied at the time of it was suitable for the post. That's just not in the minutes. This is it borders on fiction, unfortunately. It just appears out of nowhere with no documentary evidence to support it whatsoever.
I'm sorry.
Yeah,
who am I listening to?
paragraph 19.
Is that Mr.
The applicant
Wickett?
also contends it was irrational and logical because the applicant would have undergone the process twice. If substantially appointed to the post, the applicant will have to serve a probationary period.
I think you made that.
Yes, he was not satisfied at the time of it was suitable for the post. That's just not in the minutes. Right, this is, it borders on fiction, unfortunately. It just appears out of nowhere with no documentary evidence to support it whatsoever.
Sorry.
Paragraph 19, the applicant also consented to rational and logical because the applicant was undergone the process twice. As if substantially appointed to the post, the applicant would have to serve a probationary period.
I think you made that.
Yes, he was not satisfied at the time of the suitable for the post. That's just not in the minutes. Right, this is, it borders on fiction, unfortunately. I think we're stuck in a loop. Documentary evidence to support it whatsoever.
A bad loop.
Paragraph 19, the applicant also consented to rational and logical because
Let
Well,
me
okay.
stand this down for a moment and just have a exchange with Mr. Connor.
Thank you, Lynn.
Yes, certainly.
Did you do a court smart playback by any chance, Mr. Connor? Mr. Connor, do you hear me? Avita? You're on mute. Stand this down for a minute.
Okay.
Just have a
Yes,
exchange. Did you do a court smart playback by any chance?
no, I haven't.
Yes, certainly.
No,
Did you do a court smart playback by any chance? I think everyone would just have to sign out and we'll just have
no,
to back up after lunch, maybe. I don't know what else.
Oh,
to
it's
suggest.
10 to 1, so that's a good
Yeah.
opportunity.
Avita?
yes, I can hear you. I don't know what's happening.
I think we'll just sign off until 2:30, my lady, or
Yes.
The deal's repeating
Do we
himself.
need to come back earlier than 2:30? Did you do a court smart playback by any chance?
No, I haven't.
yes, sir. If so, your ladyship can email us.
Did you do a court
Thank
smart
you.
playback by any chance? I think everyone would just have to sign out and we'll just have
No,
back up after lunch, maybe. I don't know what else. to suggest.
It's 10 to 1, so that's a good opportunity.
Avita?
yes, I can hear you.